Judge Barzinas presided over two matters, a motion to dismiss and a motion to dismiss for double jeopardy. The dilemma facing the court is whether or not double jeopardy is at play with the criminal felony charge of murder, as Ken Tsao entered a no contest plea to simple assault as a misdemeanor at his arraignment hearing in the case. While the government argued that no plea was entered because Ken Tsao did not verbally say, "I'm guilty" or no contest at his arraignment, double jeopardy doesn't apply. But as the motion was heard, Judge Barzinas clarified that the government was aware of the victim's passing before the arraignment hearing and questioned why the AG didn't dismiss the misdemeanor case when Ken Tsao was scheduled for arraignment on both the misdemeanor and felony charge on the same day. Prosecutor Sean Brown told the court that the misdemeanor case was called first and that they didn't want to dismiss the lesser charge in fear that Ken Tsao would be released without conditions and run. Ken Tsao's attorney, Randall Cunliffe, shares a different view, adamant that double jeopardy applies because the no contest plea entered by the court is a conviction.
All they have to do is object, and the judge won't allow the court the plea to be entered. They object, say, "We object, Your Honor," and the judge is going to say, "I'm going to enter a not guilty plea." I mean, you guys are probably aware, in the federal court, there's a guy been trying to plead guilty for the longest time, and the court won't accept his plea. The judge doesn't have to, So, it's just a scare tactic. It's just, crying wolf.
Brown argued that Ken Tsao entering a no contest plea for the assault charge was a trick used by the defense to avoid felony prosecution, a notion that Cunliffe disagrees with.
I'm allowed to do it. How's that a trick? It might have been smart. I might have been smarter than they were, seeing the opportunity for my client, and, they bear the burden of the problem of not having dismissed the case sooner, or not having spoken up and said, don't allow him to plead no contest.
While Judge Barzinas has taken the matter under advisement, Brown stressed that the AG is concerned that if the judge rules in favor of Ken Tsao, it would prompt other defendants to plead out to lesser included charges to avoid felony prosecution, adding that the delay in the felony indictment was not a result of bad faith on the government's part. However, they could have done better. It was indicated that the court's decision could prompt an appeal being filed with the Supreme Court.